May it please the court. Good afternoon, Judge President, Honorable Judges, esteemed colleagues. My name is Emmanuel Macharia, and I bear my co-counsel, Ms. Fiona Mwaura, on behalf of the prosecution. I'll be addressing the court first for 11 minutes on the issues on jurisdiction, and thereafter my co-counsel will address the court for 13 minutes on the issues on admissibility as well as individual criminal responsibility. We shall be serving 5 minutes for rebuttals. Thank you, Your Honors.
Thank you.
May it please the court. Mr. President, Your Honours, my name is Jacqueline, and it's an honour to appear before this court on behalf of the defendant, Lieutenant Adelaide, in these proceedings. I'll address the court for the full 25 minutes on all three issues and reserve 5 minutes for rebuttal, if it pleases the court.
Thank you very much, and let's start without further ado with the prosecutions.
May it please the court. Honorable Judges, today's case concerns the destruction of religious and cultural buildings, which bear immense historical and spiritual significance. The destruction of these buildings not only transcends the mere physical structures, but also inflicts psychological and emotional harm to its victims. But sadly, this is the harsh reality that the Typhoon community in Mestia and in Tychus have to grapple with each and every day. And the most saddening part is that, despite pressure from local and civil society organizations, the Republic of Mati has not taken any action whatsoever to investigate or prosecute these crimes. With this in mind, I'll proceed to show that this case falls within the jurisdiction of this Honorable Court. Guided by the tenets of Article 19, Sub-Article 1 Statute, this court bears the solemn duty to satisfy itself that it has the requisite jurisdiction over all matters brought before it. The prosecution humbly submits that this court has the requisite territorial jurisdiction, temporal jurisdiction, and subject matter jurisdiction. I'll begin by addressing temporal and territorial jurisdiction and later turn to the subject matter jurisdiction of this court. With the leave of the court, I'll now proceed. In accordance with Article 11 of the statute, this court shall assume temporal jurisdiction if the crimes were committed after the entry into force of the statute. Pursuant to paragraph 1 of the case clarifications, the Rome Statute entered into force for the Republic of Mati in the year 2018. And the crimes with which Lieutenant Adelaide stands charged today were committed in 2020 and therefore fall within the temporal scope jurisdiction of this court. With reference to the territorial jurisdiction of this court, as per Article 12, Sub-Article 2A of the statute, this court shall assume territorial jurisdiction if the crimes were committed in the territory of a state party or by a national of a state party. Pursuant to paragraph 16 and paragraph 19 of the record, the crimes were committed in Mestia and in Tychus, which form part of the geographical territory of the Republic of Mati, and consequently, the prosecution submits that this court can assume territorial jurisdiction over this matter. I'll now turn to address our submissions on subject matter jurisdiction. The prosecution humbly submits that there are reasonable grounds to believe that a crime under Article 8, Sub-Article 2, Roman E4, Article 8, Sub-Article 2E4 of the statute were committed in the Republic of Mati. That is the war crime of intentionally directing attacks against protected buildings which were not military objectives. We also submit that the required elements to charge Lieutenant Adelaide under this article were fulfilled in this particular case, and we'll proceed by making two main arguments. Firstly, that the crimes occurred in the context of a non-international armed conflict, and secondly, that Lieutenant Adelaide intentionally directed attacks against protected buildings. Onto a first submission on the nature of the conflict. The parameters for determining the existence of a non-international armed conflict were set out by this court in its dual judgment of the case of Prosecutor versus Ntaganda of 2019, particularly at paragraph 703, where the court held that a non-international armed conflict would exist when there is a protracted armed violence between governmental authorities and organized armed groups within a state. The chamber interpreted this test as consisting of two criteria: the level of organization and the intensity of the conflict that existed. Onto a first submission on the level of organization. If I may draw this court's attention to the ICTR's trial judgment of the case of Prosecutor versus Haradinaj, particularly at paragraph 60, it is presumed that governmental authorities meet the requisite degree of organization to engage in a non-international armed conflict. Subject to paragraph 5 of the record, Lieutenant Adler's troops, being governmental troops, met this degree of organization. With reference to the level of organization that is required for an armed group, this court, again in the case of Prosecutor versus Ntaganda, particularly at paragraph 704, set several indicative factors that show an armed group is organized, such as the existence of a command structure, the group's ability to carry out organized operations, the availability of military equipment, and the extent and involvement of military activities within the region. The prosecution humbly submits that all these factors existed within the Republic of Mati. And Your Honors, allow me to substantiate these. With reference to the existence of a command structure, despite the TPDF lacking a formally written down structure, the prosecution submits that the TPDF had an informal structure. The ICTY has previously allowed for an informal structure in the case of Prosecutor versus Blaskic, where the ICTY emphasized that of importance is not the formal documentation of the structure, rather the practical functioning of the structure. And subject to paragraph 14 and paragraph 13 of the record, the TPDF had 15 founding members that gave orders that were generally followed by other TPDF members. And additionally to these, the TPDF distributed their roles on a geographical basis, wherein each senior leader oversaw roadblocks in their neighboring areas. We submit that this indicates the existence of a command structure. However, Your Honors, we preempt that the defense may argue that the existence of a vertical hierarchical organization may be required to show the existence of a command structure. We submit that this is not the case. And if I may draw the preparatory documents of this court, in particular the ICRC working paper number 29 of 1999, it was held that there is no need, it is not a prerequisite for an armed group to have explicit ranks among them, or rather to have explicit ranks among them, and also have them, work from established bases. And therefore, we submit that the TPDF does not need to have a vertical hierarchical organization, and the TPDF does not need to have a headquarters. And subsequently, Your Honors, we submit that there was a command structure within the TPDF. Beyond the command structure, it must be shown that the armed group is able to carry out organized operations. And we submit that the TPDF was able to carry organized operations for two reasons. Firstly, that the TPDF had the capacity to form a unified military strategy. And secondly, the TPDF had the capacity to divide itself into zones of responsibilities among its various commanders. With reference to the existence of a unified military strategy, subject to paragraph 13 of the record, the TPDF was able to form a unified military strategy that comprised of setting up roadblocks at strategic areas in order to protect its members. And with reference to the group's ability to divide itself into zones of responsibilities, in accordance with paragraph 14 of the record, the TPDF had the capacity to divide itself into zones of responsibilities among its various members and leaders. And consequently, we submit this also speaks to the level of logistics that existed within the armed group. As a consequence, we submit that the organization threshold was met in this particular case.
Simone, would you? You rely on what's said in paragraph 14 of the facts. Is that right?
Yes, Your Honor.
What it says there is that the 15 founders of the TPDF gave orders that were generally followed. Doesn't that seem to suggest that it was at the discretion of the followers whether they accepted those orders, in which case doesn't that undermine your argument?
Indeed, Your Honor, I concur with your assessment in accordance with paragraph 13 of the record. However, due to the vagueness of this term generally, it is to be understood as widely accepted orders were followed by the TPDF. And in any case, there's no legal requirement that all orders have to be followed. And consequently, we submit that this court should adopt a broad interpretation with regards to understanding the term that general orders were followed by the TPDF members. Thank you, Your Honors.
Counsel, can I ask a question, please? You talked about the extent of logistics in roadblocks. How much logistics does it take to set up a roadblock?
Thank you, Honor, for the question. We submit that there is no categorical number of logistics or requirement that can be used to show the level of logistics. However, this is to be determined on a case-by-case basis. For example, this court in the case of Prosecutor versus Lubanga at paragraph 537 held that the level of logistics can be evidenced by the availability of military equipment, including firearms. In this instance, subject to paragraph 13 of the record, we see that the TPDF had military equipment, and in particularly the TPDF had gunfire, had guns, and were able to engage in direct exchange of gunfire with the Martian government troops. Additionally, this speaks to the intensity of the conflict that existed within the Republic of Mati. And we submit that there existed an intense conflict in the situation in the Republic of Mati for three reasons, Your Honors. Firstly, there was constant and frequent attacks between the TPDF and the Martian government troops. Secondly, there was a fatal level of destruction of infrastructure. And lastly, the type of weaponry used was heavy in this instance. In accordance with paragraph 13 of the record, we see that the TPDF and the Martian government troops were engaged in constant attacks that occurred throughout the year 2020. And this resulted to approximately 5,000 human casualties. We submit that this is a stark testament of the intense conflict that existed within the Republic of Mati. In addition to this, the destruction of the Messian temple at paragraph 16 of the record and the protected buildings at paragraph 19 of the record serve as an evidence of the degree of destruction that was inflicted on infrastructure. In addition to this level of destruction was carried out through the use of heavy weaponry, such as anti-tank mines, guns, and mortars. And all these factors, cumulatively understood, show that there existed an intense conflict in the Republic of Mati. If there are no questions, Your Honors, I'll now proceed to address our last and final argument. We submit that Lieutenant Adelaide intentionally directed attacks against protected buildings which were not military objectives. Buildings dedicated to religion, culture, and history are considered protected, and they would only lose their protection status if they're used for military objectives. In this instance, we submit that the Messian temple and the protected buildings at Tekus did not constitute a military objective, and therefore their destruction was a direct contravention of the principle of distinction. Consequently, we submit that Lieutenant Adelaide had knowledge and intent of the protected status of these buildings, but nevertheless went ahead and gave inflammatory speeches that resulted to the destruction of these buildings. Allow me to draw your attention to paragraph 3 of the Elements of Crimes, where it is stipulated that intent and knowledge can be inferred from relevant facts and circumstances. In accordance with paragraph 16 and paragraph 19, we see that Lieutenant Adelaide acknowledges the religious use and cultural use of these buildings, and therefore this shows that she had knowledge, and consequently her intention can be seen from her acts and omissions, wherein in paragraph 16 of the record, Lieutenant Adelaide does nothing to stop these attacks, but instead congratulates her soldiers, showing her complicity and approval towards the destruction of these buildings. As a consequence, we submit that Lieutenant Adelaide had the intent and knowledge direct attacks against these protected buildings. As I conclude, Your Honors, the prosecution humbly implores this honorable court to embrace its unwavering jurisdiction over this matter. And with the leave of the court, I'll now cede the floor to my co-counsel.
Thank you very much. You have the floor.
Thank you, Your Honors.
May it please this honorable court, my name is Fiona Mwaura, appearing as second counsel for the prosecution in this matter. With the remaining time, I shall address the second issue on the admissibility of the case under Article 17(1)(d) of the Rome Statute, and the third issue on Lieutenant Adelaide's individual criminal responsibility. In addressing the second issue, given the defense raised a challenge specifically to Article 17(1)(d), I shall delve directly into this matter and shall advance my argument by making three main points. First, that the crimes were committed as part of a plan. Second, that the attacks were organized based off their motive, manner of commission, and extent of damage caused. And third, that the crimes committed greatly impacted the typhoons. Judge President, honorable judges, in the wake of the destruction of the typhoon's protected buildings, we bear witness to the loss of a people's irreplaceable culture and monuments that have been callously taken away from them. In light of this, the prosecution humbly submits that the case before you today is sufficiently grave and deserving of this court's attention. Its admissibility is based off the fact that it satisfies the gravity assessment factors set out by the ICC's pre-trial Chamber 2 in its 2010 Article 15 decision in the case of the situation in the Republic of Kenya, at paragraph 62. This is with reference to the nature, scale, and manner of commission and impact on the victims of the crimes committed. On to the first factor, Article 8(1) of the Rome Statute provides that the court's jurisdiction regarding war crimes extends to acts committed as part of a plan or policy or as part of a large-scale commission of such crimes, to which the prosecution submits that these crimes were committed as part of a plan. Planning has been defined by the International Criminal Tribunal for Rwanda in its Rebuttal trial judgment decision of 2012, at paragraph 1290, as requiring that one or more persons design the criminal conduct constituting a statutory crime that is then later perpetrated. Bringing it closer home, the ICC's pre-trial chamber in the Kenya case of 2010 provided that a plan need not be declared expressly, and as such can be surmised from the occurrence of certain events, which includes destruction of non-military property. In this case, Lieutenant Adelaide, through her speeches, designed a criminal plan that involved the commission of a statutory crime under Article 8, Sub-Article 2E Roman 4 of the Rome Statute, through her speeches. In Messia, this is evident when she stated that it was about time someone tore down the heretic culture of the typhoons, as they could not let them continue to make all their money off of heretical religious sites while pointing towards the Messian temple, which was shortly after destroyed by her troops. More so, for the attacks in Taikus, she stated that it was clear that the first attack was not enough to persuade the typhoons to obey martial laws. She then went on to add that they would not stop until they ensured that the typhoons understood that the laws also applied to them and that they could not continue to have all the heretical monuments still standing and refusing to obey the laws. Judge President, it seems you have a question.
Yes, I have a question in that regard. When you were speaking about Taikus, Lieutenant Adelaide, I'm referring here to paragraph 19 of the record, pillaged property from the museum. In your opinion, does this amount to directing an attack?
With regards to the looting of the property from the museum?
Yes, of the looting of the museums.
Thank you, Your Honor, for your question. With regards to the ICC's trial judgment in the Ntaganda case, it provided that with regards to this specific crime under Article 8, Sub-Article 2E Roman 4, pillaging, which is what Lieutenant Adelaide did, does not amount to an attack. However, what we look at is the acts of violence that were directed towards these specific buildings, which included complete destruction.
Well, thank you very much. That is very knowledgeable. Of course, this is the jurisprudence of the ICC. Do you find this convincing? If we look, let me say, we have a museum. What does a museum constitute of, if not of the objects that are in it? So do you find this jurisprudence convincing of the ICC?
Well, Your Honors, I do understand the reasoning that was provided by this court in this decision. As we can see, the looting is provided for as a different crime, which is pillaging under Article 8, Sub-Article 2, Roman 5. However, in these instances, Lieutenant Adelaide's looting actually would speak to her intention, as it showed that despite her role as commander, which expected her to stop these crimes, she then proceeded to loot the most valuable property from the museums to add to her personal collection.
Thank you very much. Please continue.
Thank you, Your Honors. With regards to the planning in this case, we see that Lieutenant Adelaide's speeches had succeeded in creating a state of mind in her troops of this criminal plan. As such, the intervening factors of a soldier shouting in concurrence in Mestia, "Yeah, let's destroy the temple," and the apparently accidental hit of the temple in Tychus, to which another soldier shouted, "That's right, let's destroy the temple and teach them a lesson," were, if anything, a continuation of this very state of mind set by Lieutenant Adelaide. Secondly, the attacks were also organized based off their motive and manner of commission. The ICC's Trial Chamber 8, in its judgment of the Almadi case of 2016 at paragraph 81, and in line with Rule 145, Sub-Rule 2B5 of the Rules of Procedure and Evidence, provided that a religiously discriminatory motive invoked for the destruction of cultural and religious sites is undoubtedly relevant to the assessment of gravity. In this case, we can see that the attacks launched on the different sites were motivated by the lieutenant's belief that the protesting typhoons were heretics and the religious monuments heretical. As to the manner in which the attacks were conducted, we see that as per paragraphs 16 and 19 of the Record of Facts, the Martian government troops proceeded to place anti-tank mines at strategic locations to completely bring down these buildings when the firing of mortars and shots was not enough, and it caused complete destruction of these buildings as they were reduced to rubble, which also speaks to the extent of damage caused. Due to time, Your Honors, allow me to proceed to our third argument on individual criminal responsibility pursuant to Article 25.3 of the Rome Statute. For a person to be held criminally liable under Article 25.3b, the ICC's pre-trial chamber, in its Article 61.7 decision of the Bagbo case of 2014, at paragraph 242, provided that he or she must order, solicit, or induce another person to commit a crime within this court's jurisdiction. In this case, we can see the Lieutenant Adelaide induced these crimes. Judge President, honorable judges, with great power comes great responsibility. In this case, Lieutenant Adelaide, as the command, had the responsibility to avert the seeds of crime and extinguish the flames of wrongdoing by her subordinates. But instead, Lieutenant Adelaide fueled this fire and planted the seeds of crime through her acts and her omissions, which constitute forms of inducing. The lieutenant's acts of inducing was through the giving of rousing speeches which contained derogatory and inflammatory language against the typhoons and their monuments. And it was the use of this kind of language, as was held by the ICC's trial chamber in its Article 61.7 decision of the Ntaganda case at paragraph 153, that then prompted the troops to proceed with the attacks.
Counsel, can I ask this question? Is your submission that the sole mode of liability under Article 3b is inducing, or are you making submissions on, for instance, ordering?
Thank you, Your Honor, for your question. Given the wording of Article 25.3b's mode of liability, which is either ordering, soliciting, or inducing, the prosecution is submitting that Lieutenant Adelaide induced the commission of these crimes. Allow me to proceed to my submission, which is that Lieutenant Adelaide's inducement can also be seen through her omissions, where she failed to prevent, she failed to intervene, she failed to punish past crimes, or even then report to her superiors or competent authorities about the crimes. And instead, after the first attack, she congratulated her soldiers, showing approval and complicity to these crimes, and after the second attack, as per paragraph 19, did nothing to intervene and instead looted the most valuable property from the museums. These acts and these omissions consequently prove the element of Lieutenant Adelaide's acts having a direct and substantial contribution to the crimes that were subsequently committed. As to the mens rea of the perpetrator under Article 25.3b, Lieutenant Adelaide was at the very least aware that these crimes would be committed in the ordinary course of events. This was evident through the nature of the inflammatory speeches she gave, Your Honors, where she spoke of tearing down the typhoon's protected buildings despite having knowledge of their protected status, as she referred to them as religious monuments, and a subsequent failure to stop the attacks in both instances. Allow me at this juncture to point out that while the court's agenda makes reference to charging Lieutenant Adelaide under either Article 25.3b and or d of the Rome Statute, the prosecution proceeded to charge her under Article 25.3b for the factors I have highlighted. Nevertheless, the prosecution still believes that Lieutenant Adelaide could be held criminally liable under Article 25.3d for her significant intentional contribution to these crimes. This was through her position in the group as lieutenant of the 4th Division of the Army, through her role of creating the plan through her speeches, her role of instigating these attacks through her acts and her omissions, and her subsequent failure to intervene or prevent these crimes, all of which are factors provided for by the ICC's Pre-Trial Chamber 2 in its 2011 decision in the case of Prosecutor versus Mbarushimana from paragraph 270 to 284.
Counsel, can I ask a question? Is there a difference between inducing the crime under 25.3b and instigating under 25.3d?
Indeed, Your Honors, there is a difference. As highlighted in the ICC's pre-trial chamber in the Mbarushimana case, it provided that for the mode of liability under Article 25.3b, it is of a higher threshold, that being the substantial contribution threshold. However, when looking at contribution in any other way, Your Honors, I can see my time is up. Allow me an additional minute to submit.
You have been asked. Please finish your answer.
As to contribution in any other way under Article 25.3d, it is that of significant contribution, which is of a lower threshold.
Thank you.
Thank you,
I think that was a sufficient answer. Thank you very much for the moment. And we turn now to the submissions by the defense. I give you the floor. You may start.
Mr. President, Your Honours, and may it please the Court. The case before you today is one that falls wholly outside the mandate of this Court to respond only to those most serious crimes of international concern. Your Honours, this afternoon the prosecution has attempted to do three things. Firstly, to impermissibly extend this Court's remit beyond its narrow and confined subject matter jurisdiction by asserting the existence of a non-international armed conflict. Secondly, they have asked this Court to admit a case of insufficient gravity beyond this Court's mandate to respond only to those most responsible for the most serious crimes. And thirdly, they have asked this Court to find reasonable grounds to believe that Lieutenant Adelaide was individually criminally responsible for crimes that were beyond her control. It's our submission that the prosecution's case today is inaccurate and unfounded, and that they have failed to advance reasonable grounds to believe that any one of their submissions is made out. Your Honours, in responding to the prosecution this afternoon, I will make three submissions. Firstly, that there are no reasonable grounds to believe that this Court has jurisdiction on the basis that there was no non-international armed conflict at the time of either attack. Secondly, and in the alternative, that there are no reasonable grounds to believe that this case is admissible on the basis that it is of insufficient gravity. And thirdly, and in any event, there are no reasonable grounds to believe that Lieutenant Adelaide was individually criminally responsible for either attack. Your Honours, if the Court finds for the defence on any one of these submissions, the prosecution's case must fail, and we respectfully request that this Court dismisses this case.
Who bears the burden of proof?
Your Honour,
And to what standard?
certainly, Your Honour. In accordance with the Bemba-Gombo pre-trial chamber in the confirmation of charges decision at paragraph 203 to 204, at these pre-trial stages there is not a clear burden of proof as in domestic jurisdictions, but rather this court must satisfy itself of each individual fact. And in the present case, the standard of proof is reasonable grounds to believe, which was interpreted in the al-Bashir arrest warrant case as requiring sufficient evidence for this court to believe that there are reasonable grounds to consider that the accused may have committed the attacks that she has been charged with. Turning to our first submission, Your Honour, it's our submission that this court has no subject matter jurisdiction to hear this case. Your Honours, we do not challenge the prosecution's submissions this afternoon regarding the temporal or territorial jurisdiction of this court, nor do we challenge their submissions concerning the material elements, with the exception of Lieutenant Adelaide's criminal intention, which I will address in my third submission. Rather, it's our submission that this court lacks subject matter jurisdiction on the basis that there was no non-international armed conflict at the time of either attack, on the basis that the TPDF was not sufficiently organised, and that this conflict had not reached a sufficient degree of intensity. And I'll address each of these two factors in turn. Firstly, Your Honours, in relation to the existence of an organised armed group, in accordance with the Rome Statute at Article 8.2f, this is a prerequisite for Your Honours to find that there was a non-international armed conflict at the time of these attacks. We accept the prosecution's characterisations of the relevant factors this court is to consider in assessing organisation in accordance with the Intergander trial judgment at paragraph 704. And while we accept that no one of these factors is individually determinative, it's our submission that in the present case the TPDF cannot be considered sufficiently organised on the basis that the prosecution has not demonstrated that the TPDF had at their disposal a force which was firstly under a responsible command with a clear internal hierarchy, and secondly that they operated under rules or a disciplinary system. And I'll address each of these two factors in turn. Firstly, Your Honours, it's our submission that the lack of clear hierarchy or internal command structure within the TPDF in the present case means that there are no reasonable grounds to believe that the TPDF was sufficiently organised. We do not challenge the prosecution's submissions regarding the fact that there is no requirement for this to be in a formal structure. However, the pre-trial chamber and trial chambers of this court have repeatedly emphasised the need for a leadership structure, hierarchy, and high degree of organisation. We submit that this is an evolution of the jurisprudence since the ICRC working paper which was relied on by the prosecution, as judgments such as Intergander at paragraph 704 and most recently the Unwin judgment at paragraph 123 have emphasised. It's our submission that in the present case this required hierarchy is absent on the basis of the facts at paragraph 14, which describe the TPDF as an organisation led by 15 founders, with these senior leaders distributing their responsibility over geographic areas. It's our submission that this represents a flat hierarchy with only 2 levels of division, and there is a distinct absence of a chain of command beyond the 15 leaders giving orders, and we submit that this is insufficient to indicate organisation. Contrary to the prosecution's submission, we submit that this is more indicative of a general association operating with the common goal, and on that basis we submit that the TPDF should not be considered organised in the present case. Secondly, Your Honours, it's our submission that the absence of evidence of rules or discipline within the TPDF is further evidence of the lack of internal organisation. In the Lubanga trial judgment at paragraph 515, this court held that organised armed groups must be capable of imposing discipline in the name of a de facto authority. This is in accordance with the requirement outlined in Article 1.1 of Additional Protocol 2 to the Geneva Conventions. It's our submission that such rules or discipline are absent on the facts. So if I can take Your Honours to paragraph 14. Here this indicates that the orders of the 15 senior members were only generally followed. We submit, contrary to the prosecution's submission, that this is not indicative of an internal system of hierarchy or orders. There was no imperative on the individuals within the TPDF to follow these orders where it did not accord with their goal of defeating the Mercian government. We can compare this to the Unwin judgment, where at paragraph 124, this court accepted that generally following orders was sufficient to indicate a level of organisation. However, I note that this court at 131 of that judgment noted that this was only in the context of clear rules requiring obedience to orders and a violent disciplinary system. As with the lack of command structure, it's our submission that this lack of rules or discipline is indicative of the TPDF's lack of organisation. And when considered together, it's our submission that this is not sufficient to indicate that there is a non-international armed conflict at the time of either attack. Your Honours, turning now to the second element that must be established, it is required that this conflict was of sufficient intensity. However, contrary to the prosecution submission, it's our submission that there are insufficient factors indicating intensity in the present case. While we accept that the number of deaths in the present case was not minor, amounting to about 5,000 people dying between June and December of 2019, we submit that at no point did this increase beyond this throughout 2020. And on that basis, this did not meet the required escalation of intensity to satisfy this threshold.
Counsel, can I ask a question?
Certainly, Your Honour.
In the Abu Garda case, which covered the situation in Darfur in Sudan, the court held that the death of 10 African Union peacekeepers could satisfy the gravity criteria, even though there wasn't a plan or policy. Do you have any submission in that regard?
Certainly, Your Honour. We accept that in accordance with the language of Article 8.1 of the Rome Statute, given it says this court will have jurisdiction over war crimes carried out especially when they are part of a plan or policy, that there is no inherent requirement that a plan or policy exists, and on that basis this court will not exclude its jurisdiction where such a plan or policy exists.
Thank you. Proceed.
Thank you, Your Honour. Turning back to my submissions on intensity, contrary to the prosecution's submission, it's our submission that the destruction of 2 buildings alone is insufficient to indicate intensity, and that there's no evidence beyond the destruction of these buildings on 2 occasions to suggest that this was more widely occurring. It's our submission that on the facts, the conflict was largely limited to armed clashes occurring between the government and the TPDF at these roadblocks. Additionally, we submit that the existence of roadblocks is insufficient evidence that there was sufficient territory covered to further indicate intensity, on the basis that the TPDF in the present case was controlling streets alone, rather than using this to assert de facto authority or control over a territory. When considered together and in conjunction with our submissions concerning the TPDF's organisation, it's our submission that there are insufficient factors to indicate that there are reasonable grounds to believe that a non-international armed conflict was occurring at the time of either attack, and on that basis it's our submission that the court lacks jurisdiction to hear this case.
Counsel, can I ask you a question?
So,
when we talk about number of victims, and when we talk about number of buildings being destroyed, and if we talk about numbers of roadblocks and the way they are manned, where do you draw the line? How do you keep the context, or where do you integrate the context in your arguments? Can you explain that to me?
is this in relation to submissions on intensity, Your Honour?
Yes.
Your Honour, it's our submission, while we acknowledge that the destruction of the buildings and the number of deaths in the present case is not minor, the jurisprudence of this court and additionally the jurisprudence of the International Criminal Tribunal for the former Yugoslavia has indicated that a factor in assessing intensity is the escalation of violence over time. It's our submission that since June of 2020, between June of 2020 and December of 2020, the intensity of attacks has remained largely consistent into the beginning of when the two attacks against the buildings were directed. And on that basis, we submit that this is insufficient to indicate intensity for finding a non-international armed conflict existed.
Please, excuse me, in the same vein, What can we say about the number of attacks in this situation?
Your Honour, it's not clear on the present case how many attacks occurred in relation to the armed clashes between the TPDF and the roadblocks. In relation to the destruction of the buildings, we know only 2 attacks occurred. This is the only evidence of destruction of property outside these roadblocks that occurred on the facts. On that basis, we submit that this is of insufficient evidence. Did you have a question, Mr.
Yes, I also have a question. Now specifically going into the issue of gravity, what's the reference point there? Are we speaking about the 5,000 deaths, or are we speaking about the destroyed monuments, museums, and so on and so forth?
Your Honour, it's our submission that when assessing the gravity of the case, this court is to have consideration to the conduct of the perpetrator and confine the court's assessment of the gravity of a case to merely the 2 attacks on the 30th of January and 12th of February. It's our submission that the number of deaths in total during the conflict period merely goes to whether there is sufficient evidence to suggest a non-international armed conflict was occurring.
Thank you for that clarification.
Thank you, Your Honour. And I will turn now to the second and alternative ground of the defence's challenge, namely that this case is inadmissible as it is of insufficient gravity to justify further action by this court. The mere fact and alleged case falls within Article 8(2)(e)(4) of the Rome Statute does not mean that a case automatically satisfies the gravity threshold, but rather in accordance with the Abu Ghada confirmation of charges decision at paragraph 32 to 33, there must be additional aggravating factors to consider. We accept the prosecution's submission concerning the factors that this court should have regard to. However, it's our submission in the present case that this demonstrates insufficient gravity, as the attacks were limited in scale, there is an absence of any particular aggravating qualitative factor, and that Lieutenant Adelaide did not play a significant part in the commission of either attack. And I'll address each of these 3 elements in turn. Firstly, Your Honours, with reference to scale, the geographic scope and temporal frame of the 2 attacks are relevant considerations. It's our submission that these were both limited, and therefore we submit that this indicates this case is of insufficient gravity. The facts state that both attacks were limited in the first occasion to just Mestia's town square, and on the second occasion to just the centre of Tychus. These were the only 2 occasions on the facts where destruction of buildings occurred, and it's our submission, therefore, that this limited scale should be a relevant factor in assessing the gravity of this case. Yes, Your Honour, yes. Turning now to the qualitative analysis, in accordance with the Abu Ghada confirmation of charges decision at paragraph 32, the factors we can consider include the extent of the damage, the nature of the behaviour, the means employed, and the impact of these crimes. Your Honours, in the Al-Mahdi trial and sentencing judgment at paragraph 77, this court noted that even if they are inherently grave, crimes against property are generally of lesser gravity than crimes against persons. In that Al-Mahdi judgment, the gravity threshold was satisfied on the basis that 10 protected buildings were destroyed over 10 days in a deliberate and systematic pattern. And additionally, all but one of those buildings had a UNESCO designation, which significantly increased the gravity in that case because of their designation as having outstanding universal value. The court put significant weight on this as an aggravating factor. We distinguish that case from the present one on a number of grounds. Firstly, on the basis that in this case, only 50% of the buildings were destroyed, none of which had UNESCO heritage designations. It's our submission that this did not occur in a deliberate or systematic manner, but rather arose in the heat of the moment as a result of the Mercian government forces' failure to break through the TPDF roadblocks. It's our submission that this lack of aggravating factors indicates that this case is of insufficient gravity. Finally, Your Honours, turning briefly to the additional factor, this court must consider the degree of responsibility of the accused. While we accept that there is no need to have a particular plan on the basis of the language of Article 8(1), and we additionally accept that there is no requirement that a perpetrator be a senior leader in accordance with the Al-Hassan admissibility appeal at paragraph 102, the accused must have had a significant role in the commission of the attack through contribution to both the organisation and the degree of participation in the attack. It's our submission that Lieutenant Adelaide, as a junior commissioned officer, was not responsible for any prior planning or coordination of the attack. We contrast this with the Almaty judgment, where Mr. Almaty had a significantly higher degree of involvement, as he directly planned 9 of the 10 attacks and was present and involved at the execution of all 10 attacks. On this basis, and in accordance with the qualitative and quantitative factors, it's our submission that this, when considered as a whole, indicates that this case is of insufficient gravity to justify further action by this court.
The prosecution say this was part of a plan. I may say they don't explain who the plan was conceived by, but let us say for the sake of argument that this is a plan devised between Lieutenant Adelaide and her troops, as seen by the actions. What do you say about that?
Your Honour, contrary to the prosecution's submission, we submit that this was not carried out as part of any plan. There is no evidence of premeditation or a design by the organisation of Mercian forces to attack the buildings, but rather this arose in the heat of the moment as a result of their failure to break through roadblocks. And on both occasions, there is no evidence on the facts that there was any kind of consideration prior to this. Your Honours, we distinguish that from the plan in the Almaty case, where it was 9 months prior to the attacks that this was considered, including specifics as to the location these attacks would be directed at and the manner of executing these attacks. And on that basis, we submit that there is insufficient evidence to consider this as part of a plan or policy. Turning to our final ground, if Your Honours are not with the defence for either of our 2 previous submissions, it's our submission in any event that there are no reasonable grounds to believe that Lieutenant Adelaide was individually criminally responsible for inducing the attacks on either the 30th of January or the 12th of February. We agree with the prosecution's characterisations on the elements that this court needs to be satisfied with. However, contrary to the prosecution's submissions, we submit that a failure to act is insufficient evidence of an inducement. In accordance with the Bemba-Gombo trial judgment at paragraph 81, a failure to act to prevent attacks or the giving of moral or emotional support is more akin to aiding and abetting, which would be charged as an alternate mode of liability. And therefore, Your Honours, we submit that this court should not have consideration to any failure to act on the part of Lieutenant Adelaide in assessing her responsibility for these attacks.
Counsel, is evidence of inducing limited to what a defendant does or says prior to the commission of a crime, or can a court ever look beyond that?
Your Honour, it's our submission that in accordance with the Intergander confirmation of charges judgment at paragraph 145, inducement is satisfied where the person exerts influence over another to commit a crime which occurs or is carried out. It's our submission that Your Honours could consider additional acts rather than just the speeches themselves. However, Your Honours must be content that the speeches constituted this inducement on the basis that, in accordance with the Bemba-Gombo trial judgment at paragraph 81, in order to establish solicitation or inducement, there must have been a direct effect on the commission of the crime. There must be a causal effect on the offence, which requires some form of pre-action by the perpetrator.
Can I?
Of course.
Yes. Yeah. How you consider the speeches of Lieutenant Adelaide?
Your Honour, it's our submission that the speeches on both occasions were mere rhetoric designed to motivate her troops and at no point directly called for the commission of the offence. I'll address Your Honours on the speeches in both attacks in turn. Firstly, turning to the 30th of January attack, if I can refer Your Honours to the facts at paragraph 15, which is where Lieutenant Adelaide made her speech. It's our submission that this was merely an attempt to motivate her troops by giving a rousing speech that was designed to inspire the crowd after the failure to break through the TPDF roadblocks. We would draw similarities between these speeches and the speeches considered by the court in the Gabgo case, which noted that a general call for action made it impossible to infer an order to attack civilians in that case, where the language was made on numerous occasions about fighting banditry in the region, and his forces having a role to quell all those against the Republic and all those who sow the mess. Your Honours, it was the facts at paragraph 16 with the comments of a soldier saying, "Yeah, let's destroy their temple," that prompted the crowd to fire. Prior to this point, there is no indication on the facts that Lieutenant Adelaide knew her comments would result in the destruction of the buildings, nor we submit should it be interpreted as sending a signal that her forces would be allowed to attack the buildings. It's our submission that these attacks were not foreseeable in the ordinary course of events, especially with no evidence as to how her soldiers reacted on previous occasions. And on that basis, we submit that she should not be held individually criminally responsible for inducing that attack. Secondly, Your Honours, in relation to the 12th of February attack, it's our submission that Lieutenant Adelaide's conduct did not have a direct effect on the commission of the crime. If I can refer Your Honours to the facts of paragraph 17, this is where the speech occurred that has been relied on by the prosecution. However, the facts in the following paragraph at 18 indicate that there was a continued occupation of the town between the deliverance of that speech and the attacks in question. The facts of paragraph 19 indicate that Lieutenant Adelaide ordered her troops to break up the protest by any means necessary. However, at no point did she give specific instructions as to how this would be carried out. The facts state at paragraph 19 that it was whilst dispersing the protesters that a soldier accidentally hit a clay statue, and it was this in combination with other soldiers yelling, "Let's destroy their precious buildings," that precipitated the attacks, rather than Lieutenant Adelaide's speech. It's our submission that this is, sorry, Your Honour.
Yes, Counsel, I have one question. We have two exhibits before us, one of which it's Exhibit 1. It's an open source material from National Channel of Unity. Does that piece of evidence have any relevance for your case, for the defense case?
Certainly, Your Honour. We note that both Exhibit 1 and Exhibit 2 indicate that Lieutenant Adelaide's order to disperse the protesters was made to ensure no violence towards the civilians, and we submit by extension any buildings in the area. And therefore, it's our submission that it is not possible to infer that she implicitly instructed her forces to commit crimes against the buildings in response. It's our submission that it was, in fact, this warning shot and the subsequent calls from the soldiers on the ground, who, in accordance with Exhibit 1 and Exhibit 2, Lieutenant Adelaide had no control over at this point, that was the direct cause of this action. There was no substantial contribution made by Lieutenant Adelaide before this point.
And do you have any submissions to make regarding the reliability of this open source document?
Noting my time, Your Honour, may I have a moment to...
Well, again, since you have been asked, please answer shortly.
Thank you, Your Honour. It's our submission that in the absence of further evidence concerning Lieutenant Adelaide's intention at this point, that this should be considered in the court's assessment, while we accept that this was made by a soldier under her command, and indeed comments made by Lieutenant Adelaide, and so may not be the most objective. It's our submission the fact that two exhibits corroborate this, and in the absence of further evidence, that this court should put weight on those two exhibits.
Thank you very much.
Thank you, Mr. President.
I turn now to the prosecution. Do you request a rebuttal? Then you have the floor.
May it please this honorable court, in the 5 minutes allocated to the prosecution for rebuttals, I intend to address 3 main points raised by the defense. First is with regards to the nature of the conflict to which the TPDF, contrary to the submission of the defense, did meet the organizational threshold. Second is with regards to the admissibility of this case, whereby the prosecution submits that it did in fact meet the gravity factors as set out in the various jurisprudence of this court. And third is with regards to Lieutenant Adelaide's inducement, particularly by omission. Onto the first factor, with regards to the TPDFs not having met the organizational threshold as alluded to by the defense, allow me to refer this court to the ICC's trial chamber in the case of Prosecutor versus Katanga in its judgment of 2014 at paragraph 1186, which adopted a flexible interpretation of the organizational threshold. As well as in the ICTY case of Prosecutor versus Boskowski in its trial judgment, at paragraph 197, it provided that for organized armed groups, they need not meet the strict hierarchy that is required for governmental forces, and as such, an informal command structure would suffice. In this case, we can see that while the TPDF did not have this strict hierarchy, they did have an informal command structure which comprised of the 15 founders who gave orders that were generally followed, and on top of them being able to carry out organized military operations as per paragraph 11, 13, and 14 of the record of facts, shows that this group was organized enough to participate in a non-international armed conflict. Allow me at this point to also clarify one of the things that was stated by the defense, that only 2 buildings were destroyed. However, while we are cognizant to the fact that these attacks took place on 2 days, we see that 5 of the typhoon's protected buildings proceeded to be destroyed. The Messian Temple, the Taikus Temple, the Museum of Typhonian Art and Culture, the Museum of Typhonian History, and the Taikus City Hall. On admissibility, as stated by the defense, the buildings in the Republic of Mati were not classified as UNESCO World Heritage Sites. However, as stated in the Almadi decision, which the defense alluded to, one of the buildings, the Sheikh Mohammed Al Arawani Museum, was not a World Heritage Site building. However, this did not deter the court from stating that it was a protected building, and as such, its destruction fell within the ambit of this war crime under Article 8, Sub-Article 2E, Roman 4 of the Rome Statute. On to the last element, the defense submitted that Lieutenant Adelaide's failure to act fell outside the ambit of the mode of liability under Article 25.3b. However, the ICC's pre-trial chamber, in its Article 61.7 decision of the Ntaganda case, at paragraph 153 and paragraph 172 and 174, provided that Ntaganda's failure to take any necessary measures to prevent or impede the activities of the Lendu in the situation in Congo did amount to inducement by omission. Drawing the comparison from that case to our present case, Your Honors, we see that Lieutenant Adelaide's acts and omissions constituted to inducing, and she hence played a role. Subsequently, her failure in the first instance to stop these attacks and instead congratulate her soldiers showing her approval, and as per paragraph 19, subsequently also refused to intervene and instead loot the most valuable property, shows that her failure to act did amount to inducing, and as such, she should be held criminally liable. Judge President, Your Honors, we cannot allow the orchestrator and architect of these crimes, Lieutenant Adelaide, to evade accountability and liability, and yet the typhoons have been left to grapple with the loss of what once stood their precious protected buildings. In light of this, as this court retreats to its chambers, the prosecution humbly requests that it rules in our favor. With that, I thank you for your time.
Thank you very much. The question goes now to the prosecution. Do you request a surrebuttal? Then please, you have the floor.
Mr. President, Your Honours, may it please. We accept their submission that there does need to be some flexibility in the organisational assessment, and we additionally accept that there is no need for an organised armed group to be as organised as a government force. However, we submit in the present case that merely 2 levels of hierarchy with no form of internal chain of command within those hierarchies is insufficient. It is important that this court is able to distinguish mere cases of internal disturbance and protests, which we submit that the present case falls under, from reaching the non-international armed conflict standard, as this is important for internal policing and law enforcement prospects, and we should not apply international humanitarian law to conflicts that fall below this threshold. Secondly, Your Honours, in relation to the admissibility submissions by the prosecution, we do not challenge the fact that the 5 buildings destroyed in the present case were inherently protected under Article 8.2e4. However, we do challenge the fact that the mere fact that these buildings were protected means that their destruction automatically meets the gravity threshold. Rather, Your Honours are required to be satisfied that there is an additional aggravating factor to consider this to be a most serious crime of international concern. In the Almaty case, this was on the basis of 9 of the 10 buildings, the large majority of them, having UNESCO heritage designation, and in addition, the systematic destruction, which was part of 9 months of pre-planning. However, in the present case, none of those aggravating factors are present. And on that basis, we submit that this case should not be considered to have sufficient gravity. Finally, Your Honours, in relation to the prosecution's submission concerning the inducement, they have relied on the Intergander trial judgment. However, I note that in that case, Mr. Intergander was charged under Article 25(3)(a) of the Rome Statute as a direct perpetrator. Therefore, we submit that the law considered by the prosecution has no application to indirect perpetration. Additionally, his liability for a failure to act was for continuing crimes, such as the continuing forcible transfer and deportation of individuals, continuing attacks against civilians, continuing rape and sexual slavery, and continued displacement. We distinguish that from the present case on the basis that these are 2 isolated attacks, and therefore we submit that this court should not be entitled to consider the omission of Lieutenant Adelaide as relevant for her liability. If Your Honours have no further questions, that concludes the defence's case.
I think there are no further questions. Then thank you very much to everyone. The chamber retires for its deliberations. Well, after a couple of days, this is also some sort of judgment. And being a judge for so many years, I know it can be really a burden. And although it's a moot court, not a real case, it was a real burden to decide today, I have to say, because in the impression of the judges, we heard an extremely impressive final round, I have to say, of a quality that we are, not often here in court, perhaps even at the International Criminal Court. So I really cannot, on behalf of all the judges, give a higher compliment to everyone who participated. And when I say a burden, then the burden was to decide who wins, who is the best team, and who is the best speaker, second best speaker. And these were, well, really marginal differences. But not to keep you too long into the limbo, so to speak. I'll wait a second, so that, because it might be important for you, what I'm going to say. Well, you are a little bit late. But since we have already decided, this could not influence you, and specifically not influence us. So we decided with the smallest margin thinkable that the prosecution team wins this contest, so to speak. Well, this applause is more than merited. You made a very convincing case, and we judges were specifically convinced by how you dealt with the jurisprudence existing, also how you referred to the facts of the case. This was what I said marginally led us to say that you are the first. Now, coming to the first best speaker, the judges decided that this will be Miss Geraldine Stark. Also with a marginal, very marginal, this marginal win, but we had really to recognize that you made the best of this defense case. Obviously, some of my fellow judges had heard other teams, and they told us, the ones, Natalie and me, who have only recently joined, so to speak, that you had a lot of arguments to present to us today that they never had heard before. And you did your case also in a convincing manner. What was specifically welcomed by us was that you did not argue against the obvious, meaning what we judges like is to say, we didn't agree, we don't have any problems with this argument of the prosecution or with that argument. This was specifically appreciated by us. The second best speaker, we decided for Miss Fiona Mwaura. I think we can give an applause for everyone. Well, obviously your presentation in the first 25 minutes was absolutely great, but the small margin that convinced us was the rebuttal, because this rebuttal was really on point. For example, you did not let the prosecution's factual slip pass away, that there were only 2 buildings, because it were more. So this was what convinced us here. We are going shortly into the deliberation room now to dress a little bit more as civil people. And then I think we proceed to the award ceremony. And I really hope that all of you will stay here and give them credit, the 2 teams who were absolutely great. And let me just repeat that. That is not to say something nice, no? Because it's of course, it's clear, you know, after all these days that you will really appreciate what the teams did. But this was really, I think it's the 3rd or 4th moot court, and these teams were the best I heard in all these years. Thank you for the moment. Please stay in the room and wait just a couple of minutes, and I think we can start then with the award ceremony. Thank you.
So, my dear friends, here we are again. Wednesday evening, I stood here on this lantern and opened the Nuremberg Moot Court 2023, and now it's about to close these 4, not years, days of intensive deliberations and hearings. 3 days of excitement, of competition, of learning and meeting. So, we've come to this moment where we present the awards for the winning teams. We have different awards, the best team, the best speaker, the best memoranda, and so forth. But before we start, I would like to convey a few thank yous, because as you know, many hands and many heads are necessary for such a great event. First of all, I want to thank Darleen Seda from Friedrich-Alexander University, who has taken on the part of the university to organize this moot court, and together with Emma Brandon from the Academy's team, who have worked wonderfully together to bring this moot court to life and to action, and have made everything so brilliantly in the way to these days and over these 4 days. So thank you so much, Darleen. Thank you so much. And of course, I would also like to thank Petra Hertel and Evelyn Müller, both from the Academy, because they have been so valuable and intensively involved in all these other infrastructural and organizational things. And with their experience, they have been, it wouldn't have been possible to organize this without them. Thank you, Evelyn. Thank you, Petra. And finally, we don't have, I'm afraid, that much time to spell out all the names, but there were so many interns and students from Friedrich Alexander University who have been here over the last 4 days so intensively guiding you and looking that the judges would feel welcomed and have everything that they need and acting as bench clerks and so forth. 3 of them are standing here in front of you, so representing that part of the Nuremberg Moot Court. Let's applaud them very heartily. And finally, a last thank you obviously goes to the judges. I can't really express my gratitude in an adequate way, but I think this is really so fantastic. So many of you come or have been coming for so many years, and I know by all the stress that you have in your professions that you stay for a couple of days or even the entire 4 days here and grow with the teams in the cases. That's so great to see, and it's really a wonderful experience for me to see you do this in sort of without giving you money, without charging. You're committing so immensely to this moot court. I'm so extremely grateful, and I know that the students are too, because for them it's so important to meet high-ranking judges at the ICC, to meet different professions, different people from different countries, from different legal cultures. That's so extremely valuable. So thank you for your commitment. So before we then come to the presentation of the awards and the handing out of the participation certificates, it's my pleasure now to hand over the word to 2 persons. One of them is Bertram Schmitt, who you just seen because he was sitting as the presiding judge of the final of this year's moot court. And it's a good tradition that the presiding judge is allowed to address the community here in this room. And I'm also very pleased to welcome my president from the Friedrich Alexander University, Professor Joachim Hornegger, who is here tonight with us and who would also like to address the audience. Bertram, the floor is yours. Thank you.
Well, allow me just a couple of words at the end of this year's moot court. This year's moot court coincided, as you all know, with the celebrations of the 25th anniversary of the Rome Statute. But did we have to celebrate anything? I've asked that myself, and I think we should ask ourselves this. I would answer with a conditional yes. Yes, because the Rome Statute is an essential contribution to the rule of law in international affairs. Yes, because the principle of complementarity has led states to incorporate international crimes into their legal systems. This further contributes to establish a global culture of law. Furthermore, the cases that we deal with and have dealt with at the ICC, they are real, they are proof that the ICC is operating. And I think this year's moot court case was at least loosely inspired by the Almaty case of the International Criminal Court. And now come the conditions. We all know there is still a lot to wish. Many countries have not joined the Rome Statute system. It is therefore encouraging that, again, so many teams from non-state parties have participated in this moot court. Our cases at the ICC, present and past, reflect only a small portion of mass atrocities worldwide. And sometimes I'm thinking even a smaller portion from year to year. So, in sum, we've come a long way after 25 years, but there is still a long, long road ahead of us. And now I'm finally turning to you, to the young people here in the room, because the road ahead must largely be taken by the participants of this moot court, by the young people, by the young generation. The future belongs to you, not to elderly judges. You have to be the multipliers for the objectives of the Rome Statute in your countries. You are the ones who will have to shape the future of international criminal law, hopefully to the better. This will not be easy. The evolution of international criminal law has never been linear, has never been straightforward. There have always been hiccups, backlashes, so we have to fight for each step. But when I see your commitment, your enthusiasm, and we just heard it, if you have stayed here, your abilities, your legal abilities, your abilities rhetorically, with argument, then I'm absolutely confident that the future is positive for international criminal law and also specifically for, let me say, my organization, the International Criminal Court. And speaking for me, I would like to thank all the participants of this moot court. We have given us, and specifically also me, a great pleasure. And what can I ask more for on a holiday, so to speak, that I have at the moment? We are soon then proceeding to the award ceremony. Thank you again to you, and I really, really hope that you will continue in this international field. Not for everyone it will be possible, but don't forget this experience, specifically in this courtroom, and don't forget the objectives of the Rome Statute. Thank you.
Ladies and gentlemen, esteemed participants and judges, organizers and supporters, I'm deeply grateful for the privilege of addressing all of you in this extraordinary setting here in Nuremberg, the illustrious Courtroom 600 in the historic Palace of Justice in Nuremberg. Standing here within the halls where justice was sought after one of the humanity's darkest chapters fills me personally with profound gratitude. This courtroom, the room 600, where the trials of major war criminals took place over 7 decades ago, serves as an important reminder of the immense responsibility that rests upon our shoulders. It reminds us that the pursuit of justice knows no boundaries and that the decisions made within these walls have reverberated throughout history, shaping the course of international law. While we reflect upon the past, we must also cast our gaze towards the future. The challenges we face today are intricate, interconnected, and constantly evolving. Climate change, global conflicts, war in Europe, and the field of human rights violation or emerging technologies like artificial intelligence demand our attention and necessitate legal frameworks for that are robust, adaptable, and of course, equitable. It is in the hands of the young legal minds like you are here, gathered here, that we entrust the critical task of shaping the future of international law. We are immensely proud to co-organize and to host the Nuremberg Moot Court, a remarkable opportunity to enhance students' knowledge and skills in international criminal law. Therefore, I extend my heartfelt congratulations to all participants for seizing the chance to engage in this prestigious international law competition. Hosting and participating in such an esteemed event aligns the practical focus of our School of Law, which is committed to imparting core skills and facilitating professional development and networks. Since the establishment of our university in 1743, the School of Law has significantly contributed to Erlangen's reputation and remains a central hub for legal knowledge and education. FAU, the short term for our university, has a unique profile as a full-spectrum university with campuses in 2 cities and is renowned for its expertise in international law and politics. Many of you, of course, are familiar with Professor Safferling's work. He's an expert in criminal law and public international law, and he is one of your hosts today. You may also recognize his esteemed colleagues, such as Professor Markus Krajewski, an authority in international law, and esteemed judges presiding over this year's Nuremberg Moot Court. Furthermore, you might know, and you should know, you most probably know Professor Heiner Bielefeld, an expert in human rights and in human rights politics. He is a prominent representative of our university. These are accomplishments of individuals that closely collaborate with Nuremberg-based institutions are very important to push forward our human rights activities at our university. And we are very grateful for the strong link to the Academy of Nuremberg Principles, which is not only a co-organizer and co-host of this moot court, but also a foster and fruitful partnership over the years. I would like to express my sincere thanks to Professor Safferling and his dedicated team, as well as our students who displayed unwavering commitment in preparing for, organizing, and hosting this extraordinary event. Moreover, the judges deserve our utmost appreciation for their invaluable contributions, overseeing the cases, providing support to the participants, and offering a realistic portrayal of an international law court. Thank you for your significant role in making this moot court a resounding success. Passion lies in the core of our values, just as diversity does at FAU. I'm delighted to welcome participants from all continents, as it demonstrates our commitment to inclusivity and global engagement. As we depart from this historic courtroom, let us carry the important lessons we have learned during our time here. May we remain aware of the transformation power of the law to effect change and ensure accountability. Let us be inspired to face the challenges and ensure the courage and compassion that is required to shape our future. Take the spirit of the Nuremberg Principles with you and let the lessons you have learned guide your future endeavors. Thank you very much.
Hello again, everyone. First of all, congratulations to all teams for participating and for your incredible performances. Now we have the great opportunity to present the winner certificates. They are the awards for first place, second place, first best speaker, second best speaker, best memoranda of prosecution, and best memoranda of defense. So we will get right to this. If we can have Bertram Schmitt and Joachim Hornegger rejoin us to help with the handout of the certificates. We have our esteemed guests.
So we'll start with the winning team. Team number 92, Strathmore University. Please come forward.
We should be in the photo now. Yeah, no. We should be in the photo.
I think that's better. Because I didn't contribute too much.
Now we have the second place team, team number 87, Macquarie University.
And now for this next award, Best Speaker from Macquarie University, Jacqueline Stark.
Non-routine case now.
Now the second best speaker from Strathmore University, Fiona Mwaura.
Now it's routine.
And the next award is Best Memorandum Prosecution, goes to Yerevan State University.
Now, the best memoranda for the defense goes to Singapore Management University. No. They go home? Yeah. It appears that they have left. I guess they had, so we will send them their awards. All right.
So that concludes the awards given this evening. We'll now move to presenting the certificates of participation to all the teams. So how we will do it, we'll ask one representative of the team to come collect the certificates of all their members on their behalf. So we'll start with Universität Bayreuth.
All right, so when they do the handover,
Yeah.
Yeah. Next, the National University of Management.
Next, we have Cagayan State University, Tuguegarao City. Sorry for the pronunciation.
Next, we have Modern International Law Studies.
Next, we have National Chinese University of Hong Kong.
Next, we have Friedrich Alexander University, Erlangen, Nuremberg.
The next team is University of Glasgow.
Next is Lloyd Law College.
And then we have Université de Lille.
And then we have the University of Eastern Piedmont.
Next, we have Olabisi Onabanjo University.
Next, we have Yerevan State University.
Russia Armenian University.
Universitas Gadjah Mada. Yeah, I'll say it again. Universitas Gadjah Mada. There are no representatives? That's okay.
Okay, so we move to the next one, Università degli Studi di Milano.
Next, we have the University of North Texas, Dallas.
Also seems like they're not present, so we move on to National University of Singapore.
Okay, also seems like they're not present, so we move on to Tribhuvan University. There we go.
Next, we have University Malaya.
Next, we have Lund University.
And Next, we have Faculty of Law, University of Colombo, Sri Lanka.
Next, we have La Trobe University.
Next, we have Singapore Management University.
As they're not here, we will move on to De La Salle University. Tanada, Yakno School of Law.
Next, we have City University of London.
And next, we have National Law University of Jodhpur.
The next team is Philipps Universität Marburg.
And next we have the University of Pristina.
And lastly, we have Symbiosis Law School, Pune.
So, thank you, Emma, thank you, Darleen. And yeah, this brings me now indeed to the very end of the Moot Court, Nuremberg Moot Court 2023. It was so great to host all of you here, and I think now we took a few minutes to again appreciate, all the universities and all the states that countries that you are coming from, and you've made such an effort, sometimes obviously days of traveling, to come to Nuremberg and to have this moot court here together with us, participating here in the Palace of Justice. I'm really proud of you all, and you can really be proud of yourself for what you've achieved, and I hope that you will think of us and of Nuremberg and of your experience still for a very long time. It was great to host you. It was a great joy to see your commitment, and I wish you now safe travels when you return home. And a little announcement, maybe not surprisingly, there will by all means be a Moot Court 2024, and this will be from the 24th of July to the 27th of July, again here in the Palace of Justice, if everything goes the way we expect it going. So do encourage your universities to register teams again for next year's Moot Court. Registration will be open from around November, and a new case then will be published in January. So encourage your teams, and maybe you, with the experience of this Nuremberg Moot Court now again in presence, you can even help coaching the team for the next year. So I would really look forward to seeing you and welcoming you again here in our Palace of Justice and at the Friedrich Alexander University. And I have to really ask you to keep the flame alive, the flame of international criminal law and the good that goes with it, or can go and can be achieved by it, and the good impression that you have, the good sentiment that you have from sitting in this room, pleading in this room or in other courtrooms here in our historic Palace of Justice. Learn, make international criminal law your cause, get involved professionally, make your states, if they haven't done so, join the belief in international criminal law and become a member of the International Criminal Court. It is and can be used to establish sustainable peace. Please keep this belief alive within you as you go home, and as I now say goodbye and safe travels. I also say goodbye to those who have been watching us on the live stream. Thank you for taking part in this award ceremony and the finals in that way. And even if you have now only participated remotely, maybe next year you can come to Nuremberg and be part of the moot court here in person. I definitely hope to see you all again soon. Stay safe. Thank you.